Okay, good morning, everybody. Welcome to the meeting of the Southern Region Hearing Board here. And I'd like to ask the clerk first to take a roll call, please.
Okay, good morning, Mr. Stovall.
Here.
Mr. Weber.
Here.
Dr. Nam. Ms. Penner. Here. Through the chair, we have a quorum.
Okay, thank you. Thank you. Little bit of an unusual circumstance today, so we've got some basically some rules, if you will, to try to make things go a little more smoothly. Our meeting today is being held in person and telecast between Bakersfield and Fresno offices, and then we have, I think, probably some people on Zoom. So we'll do our best to make this a smooth meeting, and those rules will help that to happen. But I ask you to silence all your communication devices, telephones or whatever, and that will help too. We will have Spanish interpretation, but that'll only be during the permit appeal process, not during the regular short variance hearing. If you'd like to provide public comment during the designated comment period, you can complete a card that's over there on that wall and turn it over to one of the young ladies up here in the front. Okay. Just a note that all of the participants on Zoom will be placed on mute by the host and won't be able to manually mute or unmute themselves. But they do have a little icon on there for raising your hand. And if you do that, then the moderator will arrange to get you set to speak at the hearing. When providing public comment, please state your name and affiliation and speak slowly and clearly to allow for smooth interpretation. For people attending in person, just if you would, don't sign on to the Zoom meeting, because then we get feedback, and that creates a real problem for the folks on Zoom for sure, and possibly for us here in the room. If you need Spanish interpretation, use a headset receiver that's over, I think, to the right, and that'll be available. And if you have your own interpretation device, wear a headphone with that. Okay. On the interpretation side of this, if you're on Zoom, if you're on a computer, the interpretation or language interpretation button in the Zoom controls, and then choose Spanish. On a phone or tablet, you can tap more or the three dots on the screen and tap language interpretation and choose Spanish. You can mute the original audio so that won't interfere with the Spanish interpretation. Okay. At this time, our interpreters will share instructions on how to access the translation.
Para las personas que asistan por medio de Zoom para escuchar la reunión en español. Para las personas que asistan por medio de Zoom para escuchar la reunión en español, seleccione el canal de interpretación. En la computadora, haga clic en el botón de interpretación o interpretación de idiomas en los controles de Zoom y luego seleccione español. En el teléfono o tableta, toque más o los tres puntos, seleccione interpretación de idiomas y luego elija español. Seleccione silenciar audio original para escuchar únicamente la interpretación en español.
Okay, thank you. Gracias. Okay. At this time, I'd like to introduce kind of a new person up here for some of you who are here more often. And his name is Phil J. Phil is an attorney who will be, because of the unusual circumstances of one of the things on the agenda, he will be advising the board, and the regular district staff will be doing their own thing. But Phil, I don't know if you have anything you'd like to.
Delighted to be here. Thank you.
Okay, great. So with that, everybody's got kind of the ground rules all set. I'd ask any witnesses who intend to be testifying today to please stand and raise your right hand. Do you solemnly swear that the testimony you're about to give and the matters pending before this board, before this hearing board, today shall be the truth, the whole truth, and nothing but the truth? Okay. I think the record should reflect all responded positively. So let's go first to the consent calendar. Do we have any additions or corrections to the consent calendar? Seeing none there, do we have any public comment regarding the minutes or anything else on the consent calendar?
Any members of the public that would like to comment on the consent calendar at this time?
No. Okay.
And in Central, are there any members of the public there?
No public in Fresno.
Thank you. Okay, and there's no indication of online comments.
Okay, great. Do we have a motion to approve the consent calendar?
Motion to approve this consent calendar?
Motion by Ms. Penner,
A second.
second by Mr. Weber. If the clerk would take the roll, please.
Okay. Mr. Stovall,
Yes.
Ms. Penner,
Yes.
Mr. Weber.
Yes.
Okay, through the chair, motion passes.
Thank you. So we're going to have a general public comment period now. This time is made available for comments from the public on matters within the board's jurisdiction that are not on the agenda. Members of the public are requested to reserve comments for items on the agenda until those items are heard. Additionally, state law prohibits the hearing board from acting on matters that are not on this agenda. Do we have any general public comments?
Okay, are there any members of the public in Bakersfield that would like to comment on non-agendized items?
Not seeing any.
None in Fresno. Do we have any public comments?
No public comments in Fresno.
No indication of comments online.
Thank you. With that, let's go to our hearing agenda. I call first the matter of Chevron USA, Inc. Docket number S2615S. And as the clerk was explaining earlier, just come up to if you would state your name and spell it for the record, please.
Kurt Eknoyan, C-U-R-T, Eknoyan, E-K-N-O-I-A-N.
Okay, thank you, Kurt. Thank you. So let's first hear from the staff, and I think Will Coons, this is yours. So if you would give the staff report, please.
Yes, good
I'm gonna
morning.
have the presentation.
Sure. Good morning. My name is Will Kuhn, and I'm an air quality specialist here at the district. And before you today is Chevron USA, Inc. And Chevron operates equipment associated with the production and storage of crude oil and gas at the Con 3 oil cleaning plant within the Lost Hills oil field. The facility utilizes a series of tanks to receive, process, and ship crude oil. The tanks are connected to a vapor recovery system that collects vapors and sends them to a disposal device. Chevron needs to replace a portion of vapor recovery unit piping and 2 oil skimming units. So Chevron is requesting a short variance to allow the tanks to continue to store crude oil that are not served by a VRS and to allow the tanks to vent while Chevron performs the work. The variance is necessary to safely conduct maintenance and repair work that requires a disconnect of a portion of the tank vapor recovery system. Excess emissions are estimated not to exceed 635.5 pounds of VOCs. The closing or taking would require the storage tanks to be drained, degassed, and cleaned, resulting in more emissions than what are proposed due to the equipment and procedures involved. Chevron would need to shut in production during the cleaning process through the variance period until they bring the VRS back online. And based on daily oil production of 4,800 barrels, Chevron would lose approximately $338,000 per day. Chevron has requested a short variance from the applicable requirements of district rules in addition to the applicable conditions of the subject permits. The requested variance period would be for a non-consecutive 14-day period to occur sometime between August 12th, 2026 and November 10th, 2026 inclusive. If granted, the variance would allow Chevron to continue to store VOC-containing liquids in the subject tanks without an operating or functional VRS. The district believes the required findings as set forth in the California Health and Safety Code be made and recommends that Chevron be granted a short variance with the conditions on pages 4 and 5. And this concludes the district's presentation.
Okay, thank you. Thank you, Will. The petitioner have anything you'd like to add? Okay, and we've seen your petition, so we have that on the record. Okay, any questions for the petitioner or for Will? Do we have any public comment on this matter?
Okay, are there any members of the public that would like to comment on this case for docket S2615S? I'm seeing none in person. I do have one online, or I have some online. Okay, first one is Christian.
Okay, Christian, you have the floor.
Hi, good morning. Thank you for letting me participate remotely. My name is Christian. I live in Fresno and I work with CCEJN. The address given in the petition for the facility seems to be for their administration building. So I am unsure of the specific locations uncontrolled emissions will be occurring so that we know how close they are to residents. A 1-mile radius from the nearby Lost Hills Middle School and Community Center encompasses the entire operation around the meeting. So I believe the board should require that the actual sources of additional emissions be identified for nearby residents before this variance is approved. The variance petition cover letter states that the variance is being requested because piping for the tanks is being replaced. The only way, well, is an ATC permit done for that? I looked online, I didn't see one. And then the only way an ATC permit is not required in this situation is if the piping is being replaced exactly as it was originally permitted. Any changes because tanks have come or gone would be a change in operation, a change in permit conditions. It would need a permit. And as a reminder, the health and safety code that allows variances does not allow them to be used when a permit is required. I have a question about the 14 non-consecutive days. When there is a break in the work, is a working vapor recovery system going to be hooked up? Because if not, and the vapor recovery system is the only method of control, then emissions will be occurring for more than 14 days, and the emission estimates were only for 14 days of emissions. Sorry, I got a couple more things. The district's tank emissions for fixed crude oil less than 26 API spreadsheet is what's used to calculate these emissions. I was hoping district staff could share where this came from. And I ask because almost always US EPA is called AP42. It's just a document that was done in the 1990s that went out and found out how to calculate emissions for all these sources. Well, Chapter 7 for organic liquid storage specifically has a disclaimer that said that those emission factors are not EPA recommended and they are not to be used for permitting. And so I would just be curious. I would like to make sure that the sources used to produce that spreadsheet did not come from US EPA's AP42. Otherwise, it's not being used as that document said. And then lastly, the petition says that the permit number 23 is being assigned 9.6 pounds of VOCs per day, but its permit says that it's permitted for 220 pounds a day. So I'm wondering why the 220 is not used, since the only control emission device is removed. Thank you.
Okay, thank you, Christian. Let's go, Will, do you have any response to that? And then we'll ask Chevron for their view as well.
Yes, I would defer to the petitioner to answer the specified questions.
Okay, thank you, Will.
There's a lot, but one of them that stood out was that we needed a permit. This is a replace in kind. And the VRU is going to be running. Tanks will be pulled off separately. And the emission evaluation is according to the district's template, which we filled out accordingly when we submitted it to the district.
Any other questions for petition? No questions for the petitioner.
There is another online comment.
Another online comment. Okay.
You want me to take that one first?
Sure.
Okay. This one is webinar guest. Go ahead
Hello?
and give your comment, please.
Record should reflect there's no response.
All right. No other online comments.
Well, with that, then need discussion among the board members. Oh, if not, do we have a motion to grant the variance or with the required 6 findings that are being met and subject to the conditions set forth on pages 4 through 6 of the staff report? Is there a motion to that effect?
I'll motion.
Okay, motion by Mr. Weber.
Amend the motion to just include pages 4 and 5 of the staff report.
Oh, for,
Second that.
thank you. I think Corey is probably okay with that. Yeah.
So I move to approve Chevron USA Inc. petitions for a short variance set forth in docket number S-26-15S with the required 6 findings of the Health and Safety Code adopted by reference as set forth in the staff report. The variance shall be effective for a non-consecutive 14-day period to occur sometime between August 12th, 2026 and November 10th, 2026 inclusive, or until the proposed work is complete and the VRS is returned to compliant operation, whichever occurs first, and shall be subject to conditions on pages 4 and 5 of the staff report.
Second.
Second, okay. So we, motion by Mr. Weber, second by Ms. Penner. Clerk, take the roll, please.
Mr. Stovall,
Yes.
Ms. Penner,
Yes.
Mr. Weber,
Yes.
through the chair, motion passes.
Okay, thank you. Okay, the next item before the hearing board is docket number S-2611A, a petition for hearing and appeal of approval of authority to construct for Current Energy Refinery Project number S-1251187. Okay, just a reminder, today the hearing board is considering the district's motion to strike. The merits of the permit and the substantive issues raised in the appeal will be heard at the board meeting in October, on October 14, 2026. Our focus today is the motion to strike. Okay. The purpose of Okay, so we're not considering the merits of the permit or the substantive issues raised in the appeal unless it determines that those issues are properly before the hearing board. Each side will have an opportunity to present argument regarding the motion to strike unless the hearing board requests otherwise. Argument should be confined to the issues raised in the written motion, joinder, opposition, and reply. Ask the counsel for the different parties. So please identify yourself for the record.
Zach.
Zach?
Morning, I'm Annette Ballatori. I am the district counsel for the San Joaquin Valley Air District.
Lisa Wells, assistant counsel for San Joaquin Air District.
And we have with us here Aaron Scott, who is the permit services manager.
Okay. Okay, thank you. Thank you. And for the petitioner?
Hi, good morning, everyone. My name is Viviana Prado. I'm a staff attorney with Leadership Council, and I am counsel for 184 Community Action Group.
I'm the legal director with the Center on Race, Property, and the Environment, and counsel for
Thank you. Okay. Since this is the district's motion to strike, ask Nat and Sala to present their motion.
Morning, thank you. If staff could please pull up our PowerPoint presentation. There we go. Thank you. Good morning. Again, my name is Annette Ballatori, district counsel for the San Joaquin Valley Air District, and before you this morning is the district's motion to strike certain portions of the petition filed on the permit appeal that, as we're calling it, involving a project for an ATC issued to, or construct issued to Current Energy for a particular project that they had applied to the district for. We're going to provide you with a brief overview of that project itself, but the motion before you here today is to strike two particular claims that are raised in the petition that we believe are not within the hearing board's jurisdiction or otherwise are improper considerations for the hearing board's decision. And these two issues before you are first, whether the hearing board has jurisdiction to adjudicate CEQA claims, which Isela will be handling. And then the second issue is whether SRHB, also which stands for Community Emission Reduction Program, which I'll explain what that means when it's my turn, whether that is an applicable permitting criteria for purposes of ATC. And so with that, I will turn it over to Isela to begin her portion of the presentation.
Good morning, Chair and members of the hearing board. Just a little bit about the project. Current Energy is an independent refinery located in Western Kern County at 7724 East Panama Lane. The facility produces gasoline and various distillates, including renewable diesel fuel. The facility has been regulated since 1969, and currently there are over 100 active permits issued by the district to Current Energy. On March 12, 2025, Current Energy submitted an ATC application to install a hydrogen recovery process unit to use existing hydrogen that's already being produced at the refinery to produce clean electricity for the refinery's power needs. The project is designed to generate on-site power, reducing reliance on grid power by employing zero-emission hydrogen fuel cells. The project underwent a concurrent 30-day period to receive public comments, as well as a 45-day period to receive EPA comments or an EPA certificate of conformity. No comments were received by either EPA or CARB. On January 12th, 2026, the community requested and the district voluntarily held an in-person public meeting and extended the public comment period through January 27th, 2026. So in total, the project was available for public review for 91 days. Following the public comment process on April 30th, 2026, having determined that the project satisfied all applicable district, state, and federal regulations and was categorically exempt from CEQA on multiple grounds, the district issued ATC S37-178-0 to Kern Energy, authorizing it to construct the hydrogen recovery unit. CEQA, which stands for California Environmental Quality Act, is California's comprehensive environmental review statute. It requires public agencies to consider the environmental consequences of discretionary projects before approving them and to inform the public of those potential environmental effects. CEQA regulates how various public agencies conduct environmental review, depending on their specific permitting roles, and establishes the procedures by which those determinations may be challenged. The issue today with regards to CEQA is not whether petitioners disagree with the district's CEQA determination. It's whether the hearing board has jurisdiction to adjudicate that determination. And the district submits that it does not. Once the statutes governing the hearing board and the statutes governing CEQA are considered together, the answer is straightforward. The legislator created a specific framework for challenging CEQA determinations, and that framework does not include an air district hearing board. Petitioners are not merely alleging that the ATC violates a district permitting rule. They allege that the district improperly relied upon various CEQA exemptions, failed to assume the proper CEQA rule, and issued the ATC without the environmental review allegedly required by CEQA. Those are CEQA claims. They require a decision about whether the district complied with CEQA, not simply whether the ATC complied with applicable air quality permitting requirements. CEQA has its own, a couple of the arguments we're going to go over here is CEQA has its own comprehensive framework for challenging an agency's alleged CEQA violations. Those include specialized judicial review procedures and administrative appeals to elected decision-making bodies. The hearing boards determine whether a permit was properly issued is limited to applicable requirements of the Health and Safety Code and does not extend to claims for CEQA violations. That being said, the legislator did not leave CEQA challenges without a forum. CEQA contains its own comprehensive framework for challenging an agency's determination, CEQA determination. The statutory scheme goes further. It provides specialized judicial procedures for those challenges. The legislator directed courts to give those procedures preference and directed superior courts to develop expertise in CEQA and related environmental and land use law. Public Resources Code 21-167 governs actions to attack, review, set aside, void, or annul an agency's CEQA determination, including claims challenging exemption determinations or alleging that an agency failed to conduct the environmental review that is required by CEQA. That includes the types of claims petitioners are making here. Claims challenging an exemption determination and claims alleging that an agency failed to conduct the review required. There is nothing comparable in CEQA giving an air district board authority to decide whether the district complied with CEQA. CEQA applies to many different public agencies, from general land use permitting agencies such as counties or cities, special district agencies such as water boards, port authorities, and the like. Nothing in CEQA assigns any role to an air district hearing board to determine whether a public agency, like an air district, properly complied with CEQA. The legislator's creation of this specialized judicial review process demonstrates that CEQA's disputes are intended to be resolved in superior court, not before appointed administrative bodies with limited statutory authority. Petitioners may point to administrative appeal provisions, but those provisions do not solve the jurisdictional problem here. In limited circumstances, CEQA authorizes an administrative appeal, but only to lead agencies' elected decision-making body, not an appointed administrative tribunal that lacks CEQA appeal procedures. Administrative appeals lie only to an elected body that actually exercises project approval authority. Public Resources Code Section 21-151C, together with CEQA Guidelines Section 15185, provides an administrative appeal in certain circumstances. The hearing, and that is when it's an elected decision-making body. This hearing board is not the elected governing body contemplated in those provisions. It's an appointed administrative tribunal whose jurisdiction is defined by the legislator through the Health and Safety Code. The hearing board is authorized to hear specified categories of matters, including permit appeals, permit suspensions and revocations, variances, and related proceedings. In regards to permits, section 42302 and 42309 of the Health and Safety Code define the hearing board's authority by authorizing hearings concerning permit issuance and prescribing the specific actions the hearing board may take. Pursuant to section 42302.1, the hearing board's role is limited to whether a permit was issued properly. So if CEQA does not give this hearing board jurisdiction, the next question is whether the Health and Safety Code does. The Health and Safety Code gives the hearing board authority over the specified matters, permit appeals, suspensions, revocations, and variances. Petitioner's answer essentially is that the hearing board can decide CEQA issues because section 42302.1 allows it to determine whether a permit was issued properly. But that phrase cannot be read in isolation. Section 42301 tells us that the air pollution control officer, APCO for short, must determine what they must determine before issuing a permit. The APCO cannot issue a permit unless satisfied based on district board adopted criteria that the project will comply with applicable orders, rules, and regulations of the district and state board and applicable provisions of Division 26 of the Health and Safety Code. That statutory context in which section 42302.1 reference to whether a permit was properly issued must be understood. Properly issued is not an unlimited grant of jurisdiction to decide every legal issue that someone can connect to a permit. If it were, the hearing board's jurisdiction would extend far beyond the statutory permitting scheme enacted by the legislator. The legislator's intent is informed by reading a statute together with other provisions in the same statutory scheme. Section 42302.1 must be interpreted in the context of the statutory scheme it appears. There's an important distinction between whether an agency complied with CEQA and whether a permit complies with applicable air quality permitting requirements. The first is governed by CEQA's own statutory framework. The second is within the statutory framework governing this hearing board. Those questions require the board, petitioner asking the board to decide whether the district selected the correct CEQA exemption, whether it assumed the correct CEQA role, and whether additional environmental review was required. Those questions require the board to adjudicate CEQA compliance itself. The fact that both questions arise in connection with the same project does not make them the same legal questions. Nothing in section 42302.1 gives the board that authority. CEQA prescribes, so to reiterate, CEQA prescribes its own framework for challenging an agency's alleged CEQA violations. Petitions for writ of mandate to Superior Court with specialized judicial review procedures and administrative review, if any, to elected decision-making bodies. The hearing board's mandate to review whether a permit was properly issued, construed within its statutory structure, is limited to compliance with the factors within 42301B. It does not extend to claims for CEQA violations.
Okay, thank you, Isela. And now I'm going to be addressing the second issue raised in our motion to strike, whether a SRHB community emission reduction program complies with or satisfies or is applicable permitting criteria for purposes of ATC issuance. The petitioners claim that the district was required to analyze the current energy project against the Community Emission Reduction Program, or SRHB, for the AB 617 community of Arbon-Lamont. We contend that this is a fairly straightforward issue, as the petitioners themselves acknowledge that the SRHB is not a permitting standard, and so the answer is clearly no, But what I'd like to take a few additional moments of your time to explain is why the SRHB is not relevant to the hearing board's decision regarding whether the permit was properly issued. As Isela explained, the overarching statute, which tells the district what it must consider when deciding how to act upon a permit application, is Health and Safety Code Section 42301B. It requires the APCO to evaluate whether the project, as proposed, will comply with all applicable orders, rules, and regulations of the district and of the state board. And secondly, all applicable provisions of Division 26 of the Health and Safety Code, which is generally the division of the Health and Safety Code which addresses air pollution regulations. A SRHB, however, is neither of these two factors. Neither the SRHB as a whole nor the particular provisions within it are orders, rules, or regulations of the district or state, nor does it otherwise consist of applicable permitting standards. And to help explain why, I think it would be helpful for you to understand what a SRHB is. So some background. In July 2017, Assembly Bill 617 was enacted. Assembly Bill 617 initiated a statewide effort to provide for enhanced community level monitoring, separate from the monitoring the district already does on a regional basis, and to provide a framework for community involvement in finding ways to reduce toxic and criteria air pollution in communities which experience a disproportionate burdens from exposure to air pollution. The focus of AB 617 is on community engagement and community-driven actions. The entire AB 617 program is initiated at the top by CARB, which was required to develop what is known as the Community Air Protection Program Blueprint, which applies on a statewide basis. The blueprint serves as guidance to communities as they develop and implement strategies such as additional emissions reporting, monitoring, and various measures to reduce community-level emissions. One aspect of the blueprint, important for our purposes, is that CARB instructed air districts that they were to use their, quote, existing authorities in implementing measures for achieving emissions reductions. In other words, AB 617, the program did not vest districts with any new authority for reducing emissions. Every year, CARB is required to select, as it deems necessary, new locations around the state for preparation of SRHBs. In 2021, CARB selected the Arvin-Lamont community as an AB 617 community, and a community steering committee composed of residents, community organizations, and other stakeholders within the community was convened to embark on this effort to prepare a SRHB for the community. Through a public engagement process with the Community Steering Committee, the Arvin-Lamont SRHB was developed and approved by the district's governing board on June 16th of 2022, and you all have a copy of the entire SRHB in front of you that the petitioners have supplied with their petition, which is Exhibit A in that large binder. So what is in this SRHB? In a nutshell, the SRHB references existing stationary source rules, including those applicable to oil and gas operations. It includes enhanced regulatory strategies to be implemented in the community, analysis of additional rulemaking opportunities, and expedited review of AB 2588 air toxic hotspots assessments. Significant funding is also devoted to the Arvin-Lamont measures to reduce air pollution and exposure to pollution, consisting of over $30 million as reported in our last annual report, the district's last annual report in 2025, for things like making paving and sidewalk improvements, bike lane installations, lawnmower exchanges, free air purifiers, free vehicle emissions testing and repair vouchers, urban greening and vegetative barrier projects, school bus replacements, and many others. The basis for petitioners' SRHB claim is that the district did not analyze whether the project is consistent with the SRHB's emissions reduction commitments or broader objectives of reducing cumulative exposure burdens within the community. Petitioners also claimed that the engineering evaluation should have been reconciled with the the emissions increases within the project, and that the engineering evaluation should reconcile those increases with the district's obligations under the SRHB or its identified stationary source reduction strategies. But as we've seen, as I've explained, the SRHB is really not for that purpose. The SRHB is a community-wide plan for achieving emissions reductions and reducing exposure to emissions reductions. It has emission reduction targets for the community as a whole, but these targets are not designed to apply on a per project basis. So a good analogy, a similar analogy might be the district's state implementation plans the district adopts with the state for achieving national ambient air quality standards set by EPA. The state implementation plan, similar to the SRHB here, contains the measures such as rules, regulations, and other strategies that hopefully, when faithfully implemented, will achieve the emissions reductions necessary to attain the national ambient air quality standards. But our state implementation plans aren't applied on a per project basis to specific permit applications. They're region-wide plans. Similar to SIPs, the state implementation plans, SRHBs are community-wide plans for reducing emissions reductions, but they aren't designed to apply on a per project or per permit basis. A SRHB's quantitative targets are emissions reductions to be achieved through existing district authorities, which consist of the rules and regulations that do apply to permit applications. They are not per project issuance thresholds. In fact, petitioners do concede in their opposition to this motion that the SRHB is not a permitting standard in and of itself. And so for that reason, the petitioners SRHB claim in their permit appeal petition that the district should have evaluated the project against the emission reduction targets in the SRHB is legally deficient. The SRHB is not a basis for concluding that the current energy permit was not properly issued. There's no relationship between the SRHB and the district's permitting process. So there's nothing for the hearing board to decide on this point. And so to wrap this up, petitioner's CEQA claim and the SRHB claim are legal positions. As framed, this motion seeks to strike these legal claims. Petitioners are not precluded, however, from presenting evidence related to factual allegations that may be relevant to their other claims. I believe in petitioner's opposition, they asked that to whatever extent the motion is granted, that they be granted leave to amend to allege factual portions within these sequence or claims, so that those, I guess, facts and evidence are not lost in their efforts to pursue the petition on the merits. But even if those facts are alleged in the CEQA and certain portions of their petition, they would not be precluded anyways from raising those relevant facts on other aspects of their claim. And so we would then submit that granting leave to amend their petition is improper, as there's really no set of facts that they can raise which can cause their CEQA or SRHB claims to be actionable before the hearing board. So with that, the hearing board, we ask the hearing board to strike to grant the district's motion to strike in its entirety, striking section 3B of the permit appeal and section 3C of the permit appeal at the pages and lines referenced in the motion. And that concludes the presentation. Thank you.
Thank you. Thank you. Let's go then to the real party and interests. If there's anything you would like to add.
Thank you, Mr. Chairman, and members of the board. I'm delighted to be here. As I mentioned, my name is Zach Powell. I'm counsel for Kern Energy in this case. As you've seen from our written submission, we are joining the district's motion to strike the CEQA and the SRHB claims. So join in your comments here today, which I agree with. I won't rehash everything that's said, and I'll keep my comments exceedingly brief. I will simply say that this role is vitally important, but it's narrowly circumscribed. As you've just heard, that role, and as you know far better than I do, that role is to determine whether a permit is properly issued in any case, which means deciding whether it is in accord with the district's rules, regulations, and ordinances. CEQA is not one of the district's rules, regulations, and no statute gives this board authority to hear a claim under CEQA, and no rule or regulation from the district has been adopted CEQA, nor have petitioners pointed to authority that would allow the district to do so. They have pointed to some stray statements from non-binding documents discussing CEQA, but they haven't actually pointed to authority that would allow this board to review a CEQA. The very same is true for SRHB. It is not one of the district's rules or regulations. There is no statute that allows this board to review a claim under SRHB. SRHB has not adopted SRHB through its rules or regulations as an individual permitting requirement. And again, petitioners have not pointed to authority that will allow the district to do so in any way. Those separate laws have their own enforcement authorities, and they do not include this board's review. There is an old saying in the law that Congress doesn't hide. That means is that if something is important, it's usually not going to be too hard to find. Well, here, it would be significant if under CEQA or under the SRHB. And so you would expect the Health and Safety or the Public Resources Code or the district's regulations to say it if that was the case. And they said, so for those reasons and for all the reasons that the district has expressed, we can strike. Mr. Chairman, you rightfully noted that this is not a hearing about the merits. I will simply note that I think it is important to properly confine the board's jurisdiction because this is a good project from a good company. Kern has served this community for nearly a century. During all of that time, it provided clean and renewable energy, it's provided good jobs, it's provided community involvement. It's done all that since longer than any of us have been alive in this group. I am very excited for some of Kern's employees. They're a part of this community, they're proud of this community, they're proud of this project. And this project, after all, is simply a way to purify existing hydrogen, to make it cleaner, safer, and more productive and usable at existing facilities. I think that's why it's important to confine this board's jurisdiction so that it doesn't derail the project based on grounds that it does not have the right to consider it.
If I could just ask everybody, I've gotten comments from Zoom that they can't quite hear all of the council. So if you just can project, because we are using the audience mics. So thank you.
Okay, let's go then to the petitioner and provide your viewpoint.
Thank you so much, Mr. Silva. Hi, good morning to the board, Mr. Weber, Ms. Fenner, Mr. Silva, and Mr. J. As I said earlier, my name is Viviana Prado, and I'm a staff attorney with Leadership Council for Justice and Accountability, and also counsel for 184 Community Action Group. Thank you so much to the members of the public and the residents of Fuller Acres and Lamont that were able to join us here today. It's very much appreciated and nice to see some of my clients in the audience here today. The petition that we submitted to the hearing board on May 29th requests that the hearing board revoke the authority to construct permit issued to Kern Energy by the Air District. The Air District is a public health agency that's tasked with ensuring that residents of the San Joaquin Valley can breathe clean air, and the hearing board is tasked with ensuring that this mandate is fulfilled. Today, the district seeks to improperly deny the petitioners a hearing on the merits of our petition and argues that the jurisdiction of the hearing board and seeks to constrain the jurisdiction of the hearing board to adjudicate two critical issues bearing on the propriety of the issuance of the ATC permit that will have significant impacts on the residents' health and welfare. Since this petition was submitted on May 29th, the residents with whom I have worked with on this petition have continued to experience high rates of asthma, high rates of respiratory illness, and high rates of cancer. They continue to struggle to secure access to clean water. These tragedies are a direct consequence of the cumulative environmental burdens that have been strategically permitted along Green Patch Highway. Fuller Acres residents and Lamont residents are one environmental accident, one public health emergency away from disaster. The proposed hydrogen project at Current Energy Refinery will increase the material burdens and increase the risk of catastrophe in Fuller Acres and Lamont. All of the associated impacts must be considered in order to properly evaluate the ATC permit. As I said earlier, the Air District is a public health agency that's charged with ensuring clean air for residents. The US Congress enacted the Clean Air Act with the purpose of protecting air so as to promote public health and welfare. The California legislature tasked the San Joaquin Valley Air Pollution Control District with fulfilling this purpose in the valley. The California legislature recognized that the residents of the San Joaquin Valley suffer some of the worst air quality in the world, and that poor air quality poses a significant threat to the public health, the environment, and the economy of the valley. The hearing board is charged with ensuring the district's actions fulfill these federal and state mandates. The hearing board has the authority to revoke a permit if it was not properly issued. The decisions of the hearing board today are of great importance and have widespread impact. For example, this past Saturday, there was a truck accident along Highway 99, where in Selma, up in Fresno County, where 8,600 gallons of diesel fuel were spilled out of a semi-truck, and local authorities had no other safe option other than to let it burn itself out. Imagine that 8,600 gallons of petroleum were ignited on the freeway next to people's houses. I have very close family, cousins, and nephews that live very close to where that fire happened, and their health was in danger. And today, a similar situation to that could happen tomorrow in Fuller Acres in Lamont. And today you have the opportunity to stop something like that from happening again. Just 2 months ago, there was a leak of hydrochloric gas at Current Energy, and 10 people were sent to the hospital. That can happen again at any moment in Fuller Acres and send more people from both Fuller Acres and Lamont to the hospital. In the last 2 months, Current Energy has spilled over 819 gallons of petroleum or other chemicals onto the ground, and again has sent at least 10 people to the hospital. Current Energy is a repeated violator of environmental regulations. In just the past 10 years, it has amassed over 500 regulatory violations. The Air District argues that the hearing board's jurisdiction is limited by the Health and Safety Code, and thus CEQA and SRHB claims must be excluded. I agree. Your jurisdiction is limited by the Health and Safety Code. However, a plain interpretation of the Health and Safety Code indicates that our SRHB and CEQA related claims should be permitted in our permit, in our petition, and the district's motion to strike should be denied. I would now like to summarize the standard of review that the hearing board should be using today. In other words, this is the manner in which the hearing board should be dealing with the question before it. When deciding whether or not to grant the district's motion today, the hearing board must exercise independent judgment on the conclusion. The hearing board must reach a determination of its own jurisdiction in the first instance. I will now present our arguments related to CEQA, and then I'll pass it on to my colleague Natalia, who will say some more about our SRHB arguments and our SRHB related claims. So as the district mentioned earlier, the question before you today is whether the ATC permit was properly issued. The district's statutory obligations and its adopted guidance and policies clearly tell us that CEQA is a necessary step taken by the district staff before issuing an ATC permit. As the district said earlier today in its presentation, it considered CEQA before issuing this permit. The district is subject to CEQA. It's a public agency, exactly like the type that CEQA was enacted to regulate. Had the district staff not complied with CEQA, had it not enacted and gone through the CEQA process, it would not have issued this permit. It would not have been proper for it to have issued the permit had it not considered CEQA. However, the district today is attempting to constrain your authority, and it's arguing that the hearing board does not have the authority to hear these CEQA related claims. the district attempts to distinguish between CEQA determinations and an ATC evaluation under its permit rules. However, a CEQA determination for the CEQA determinations made for this project are one and the same as the ATC evaluation for this project. The engineer's evaluation for the ATC permit incorporates CEQA regulations. We know that this happened. We know that district staff considered CEQA when deciding whether or not to issue this permit because it's clearly stated in the engineer's report. The district's environmental review guidelines, its administrative policy and procedure 210, and the information available on its website, both to the public and to applicants, clearly say that the district considers CEQA in its issuance of a permit. The district is arguing that we're seeking to expand your authority today by including these CEQA-related claims in the petition. However, that is not true. A proper issuance of the ATC permit requires CEQA evaluation. The hearing board has the authority to consider all facts that go into the proper issuance of an ATC permit. A plain reading of the health and safety code will lead you to the conclusion that the motion to strike should be denied. There have been several cases in California that affirm that CEQA-related claims can be heard by a hearing board. This supports our position that there are several pathways that can lead to the evaluation of a CEQA argument, and one of those pathways is here before a hearing board. Right, in Friends of Outlet Creek and in both and in Crist Creek Aggregates LLC, two cases that we cite in our briefing, a petition was filed to a hearing board, to the hearing board of Mendocino Air Quality Management District. And that petition was similar to ours, in which an ATC permit was challenged and there was CEQA-related claims in that petition. And that petition was denied by the hearing board. And then the petitioner sought judicial review before the Superior Court. And at the Superior Court, the court affirmed that that pathway existed for CEQA-related claims. And the court affirmed that the CEQA-related claims that had been presented before the hearing board were properly heard by the hearing board. So there is case law to support that the motion to strike should be denied today. The district also argues that the hearing board should not consider our CEQA-related claims because CEQA determinations should only be made at a superior court, not by a hearing board. That would make sense if we had filed a writ of mandate to the hearing board, but we did not file a writ of mandate to the hearing board. What we filed was a petition as authorized by the Health and Safety Code. We're not asking for the type of relief that's available pursuant to a writ of mandate. We're seeking the relief that's available under the Health and Safety Code. Interestingly enough, the district took an entirely different position in 2017 in a case where an ATC permit was challenged on CEQA grounds by filing a writ of mandate to the Superior Court. So in the case of Communities for a Better Environment versus the San Joaquin Valley Air Pollution Control District, the district said that challenges to an ATC permit on CEQA grounds had to be heard by the hearing board first. So in 2017, they took a completely different position than they're taking today. Regardless of the paths that a petitioner may seek to have their CEQA-related claims addressed, whether it be under the administrative pathways provided by CEQA or the administrative pathways provided by the Health and Safety Code, the district has recognized and has even invited CEQA-related claims to be heard by the hearing board in the past. The district also argues that CEQA does not provide administrative appeals to an unelected decision-making body. However, again, we're not seeking a remedy pursuant to a writ of mandate, so this argument is irrelevant here. The case law that the district relies on for this argument, no wetlands landfill expansion, seeks review of the CEQA allegations via procedural pathways provided by CEQA, not by the Health and Safety Code. So again, that pathway is not at issue here. The pathway that's at issue here is a review of CEQA-related arguments by the Health and Safety. Lastly, Current Energy's brief and also the comments that they have made today are primarily regarding the merits of this project, and we do look forward to discussing the merits of this project at the hearing on October 14th. Lastly, before I pass it on to my colleague, I just want to say the Health and Safety Code is not ambiguous. you have the authority to consider whether a permit was properly issued. And the hearing board, the district staff evaluated CEQA in determining whether their permit was properly issued. Thus, you have the authority to consider these CEQA claims. I'll go ahead and pass it on to my colleague Natalia to speak about the CERB claims. Thank you.
Thank you.
Yeah. Good morning again. In a similar vein, here the district is relying on an over narrow interpretation of the relevant statutes that really ignores key provision and improperly omits consideration of CERB findings from its permit process. Section 42301 does not establish an on or off inquiry into proper issuance of permits, but rather requires the APCO to apply criteria adopted by the district in its implementation of district rules, orders, and regulations. Petitioner's position regarding the applicability of the Arvin Lamont Community Emission Reduction Program, or CERP, is based on a plain reading of two statutes. Health and Safety Code 42301, which describes the permit system carried out by the air districts, and Health and Safety Codes Section 44391, requires that air districts in non-attainment areas adopt CERPs and carry out mandated emission reductions in overburden. Context is key to reasonable statutory interpretation. Viviana has shared some of the powerful context behind the passing of AB 617, as did the district in their presentation, which is a law that established the creation of CERPs and aims to improve air quality, especially in overburdened communities like Fuller Acres and Lamont. Some additional context includes that the communities surrounding the current energy refinery are in the 96th percentile of the state, in the 99th percentile for drinking water contamination, and in the 98th percentile for exposure to small toxic sites. In addition to these disproportionate exposures, they also neighbor a facility that in 2019 contributed 91% of the NOx pollution from stationary sources in the Arvin Lamont area, which is the current energy and oil refinery. We ask you to really sit with these and with the lived experience shared by Viviana that reflects the lived experience of many of the residents who are here with us today, as you consider the meaning and the intention behind the statutory language in sections 44391.2 and 42301. The CERP does not need to be a permit standard in order to be criteria upon which the APCO must decide whether a permit is properly issued. The CERP is an enforceable document if the air district allows it to be by using its respective authority to comply with its statutory obligations. Section 44391.2 does not expand the district's authority, but it does impose clear requirements on air districts to adopt CERP that will reduce emissions in communities identified by CARB as overburdened by air pollution. As a program formally adopted by the district, again, as described in the district's presentation, the CERP is relevant to the district's exercise of its existing permitting authority. In order to carry out an adopted CERP, Section 44391 states that the district shall be responsible for measures consistent with their respective authority. And it briefly, in response to Real Party's argument that the hearing board's authority to consider these claims is somehow hidden, it is not. That mandate is clear. The district shall be responsible for measures consistent with their respective authority. These respective authorities include permitting authority. Section 42301 requires that districts prohibit the issuance of a permit unless the air pollution control officer is satisfied on the basis of criteria adopted by the district board that the article, machine, equipment, or contrivance will comply with all applicable orders, rules, and regulations of the district and the state board and all applicable. To conclude otherwise would water down the mandates of section 44391.2. The district's contrary reading treats the CERP as irrelevant to permitting and excludes consideration of district adopted findings, which contradicts its statutory emission reduction mandate. The CERP provides important context for evaluating whether the district adequately explained and supported its permitting decision, including its analysis of health demographics, cumulative environmental burden, pertinent refinery-related VOC and toxic air contaminant emissions, and These relevant findings also include the disproportionate contributions of current energy to local air pollution. As I mentioned previously, the SERP describes the current energy refinery as a major stationary source of NOx emissions. Of the 55.1 tons per year that made up the community emissions inventory for Arvin and Lamont in 2019, current energy contributed 50.59 tons per year, or 91%. And yet, the district in its permit determination did not analyze whether additional emissions from this the district's statutory obligation to reduce emissions in Lamont and Fuller Acres as described in the survey. The district's reading of the statute that the criteria upon which the APCO must base its permit determination refers only to district rules, contradicts statutory interpretation principles that require that significance, if possible, should be attributed to every word, phrase, sentence, and part of an act in pursuance of the legislative purpose, as the various parts of statutory enactment must be harmonized by considering the particular clause or section in the context of the statutory framework as a whole. When the district, ultimately, when the district concludes that the Arvin Lamont SERP amounts to nothing more than a non-binding aspirational programmatic plan containing only the recitation of existing district rules independently of the SERP, implemented solely through existing authorities, it strips any meaning from the statutory requirement in section 44.391.2 that the SERP shall result in emission reductions. If existing rules kept communities like Arvin and Lamont safe, we wouldn't need AB 617 and the SERPs in the first place. The motion also implies that the meetings are the appropriate forum to determine whether the hydrogen project proposed by Current Energy is consistent with the strategies and emission reduction goals contained in the Arvin Lamont. However, since the CSC does not have any granted authority to independently implement the strategies contained in the SERP, this suggestion ignores the district's statutory responsibility to carry out the SERP measures consistent. In summary, petitioners do not seek to establish a quantitative target for permitting, but rather we're asserting that the district is simply required by statute to consider the SERP findings in its permit determination. Ultimately, the hearing board has jurisdiction over whether the district in its issuance of a permit properly considered both CEQA and SERP related. For these reasons, the district's motion to strike should be denied. However, as mentioned, if the hearing board grants the motion, we are requesting the opportunity to amend our petition. Thank you for your time and for any questions.
Thank you. We'll have a question session here after we hear all of the arguments. Thank you. With that, let's then go to the district council and we'll hear your rebuttal.
Okay, thank you. Just to respond to a couple of commissioners' points. The district has never denied that CEQA is a necessary step required to comply with in their permitting processes. But that obligation is not found within the Health and Safety Code, it's found within the Public Resources Code. The district, just like many other public agencies that aren't Air District, nearly all public agencies who make discretionary decisions are required to comply with CEQA. But that separate statutory framework is separate from what the hearing board must decide within its limits. Whether the permit was properly issued in reference to that proper issuance criteria that the APCO is required to apply, set forth in section 42301, board's orders, rules, and regulations, and applicable provisions. To kind of put a little bit further support on that and to address some of their arguments. They bring up Friends of Outlet Creek and Grist Creek aggregates cases that they've cited in their opposition and that we've also responded to in our reply brief. Those cases really don't support the specific issue of hearing board jurisdiction, Air District hearing board jurisdiction for CEQA issues. Those cases didn't decide the issue at all. It was assumed, I guess, it was perhaps their particular agencies had different rules or regulations that maybe, authorized hearing board jurisdiction, specifically authorized CEQA jurisdiction for their hearing boards. We don't know. But they did not address the issue directly that is before you here today. However, the case that the district has cited in its reply brief, Covington versus Great Basin Unified Air Pollution, did directly confront the argument that section 42302.1 and district permit rules required a petitioner to exhaust administrative remedies to an air district hearing board before bringing a CEQA challenge. In that case, rejected that argument, holding that the exhaustion requirement for CEQA actions are set forth in Public Resources Code, not within the CEQA code. And so by treating the two statutes as governing separate and distinct administrative processes, the permit challenge in that case, that published decision under section 42302.1 and CEQA challenges under Public Resources Code, the court explicitly made a distinction between those two separate administrative processes. Similarly, the case that we cited, Mill versus Bay Area Air Quality Management District, was a case where a hearing board dismissed a CEQA-based appeal of a district permit for lack of subject matter jurisdiction. And in there, the Court of Appeal affirmed, holding that the applicable reviewing body, whether a district hearing board or a federal environmental appeals board, is confined solely to the issues directly cognizable under the governing permit statute, that CEQA compliance is a state law matter falling outside the permit review process. On their point that the district took a different position in a prior case, the district was a party several years ago in a case called Communities for Better Environment versus the Air District, which raised some CEQA challenges in that case. And in that case, the district did not argue, as petitioners allege, that CEQA challenges to an ATC must first be brought before the hearing board, but instead the district argued that challenges to its permitting determinations under the Clean Air Act, such as collateral attacks on the district's emissions calculations and application of its permitting rules, were subject to the hearing board appeal process. And in fact, in that case, the court rejected that argument because the petitioners in that case disclaimed any challenge under the California Clean Air Act and only alleged CEQA violations. And so the court in that case held that CEQA's own exhaustion provisions governed those claims, and that hearing board jurisdiction under 42302.1 was irrelevant to whether plaintiffs may bring a cause of action under CEQA. So really contrary to what petitioners are alleging, the court's outcome in the decision also helps support the notion that hearing board jurisdiction is separate from CEQA jurisdiction. And then on the SRHB issues that they are raising, again, they're attempting to equate, I guess, criteria adopted by the board that an APCO is required to apply in determining whether a project complies with district orders, rules, and regulations. The APCO is to be guided by the separate board-approved criteria. A SRHB is not board-approved criteria for permitting purposes. Board-approved criteria for permitting purposes is found within other district rules, such as standards for granting an application and other district rules that specifically guide the APCO on how they're to review and apply the district's rules and regulations to a permitting application evaluation. That is not SRHB. The petitioners admit that section 44391.2, which is the health and safety code, which provides for the creation and preparation of a SRHB, does not expand the district's authority. And that's the point we're trying to make here, is that the district's authority for adopting rules and regulations, the district has authority for adopting rules and regulations, and once adopted is required to apply those rules and regulations in the context of a permitting project. A SRHB identifies what those rules and regulations are as part of the strategy for reducing community-based emissions, along with many other strategies which are contained in the SRHB. And if you look And Exhibit A, starting on page 67, those emission reduction strategies are all laid out for the Arvin Lamont community, and they consist of many, many things besides simply applying the district's rules and regulations. They also consist of enhanced enforcement strategies. They consist of incentive measures that are designed to reduce emissions within the community. It's a plan, it's an overall plan. It's not a per project, it's not per project permitting criteria. And that, I believe that addresses the comments that I wanted to address with petitioner's arguments. I'll turn it back to the board for any further questions or discussion. Thank you.
Okay, thank you. Would the real party in interest like to add anything in rebuttal?
I will keep it very, very brief. Thank you, Mr. Chairman. I will simply say there's been a lot of discussion of the various cases that the parties have cited on each side. I think what you'll find is that those cases lead you back to the context of the Health and Safety Code. At the end of the day, the Friends of Outlet Creek case, the Griswold case, all they really did was consider a writ of mandate brought to the court for decision under CEQA. The case in which the district was involved, as they say, their position all along was that if it was a CEQA claim, you didn't need to exhaust the remedy, go straight to court and get a writ of mandate. That's all consistent with our position here. We also cite the Valero case, which is dealing with emissions banking. At the end of the day, what it says is that the hearing board shouldn't be conducting some abstract review of fairness. It should be asking whether the permit complies with the district's rules, orders, and regulations. So at the end of the day, this is all going to lead you back to the plain text of the Health and Safety Code. And in that respect, I do agree with the petitioners. They said you can look at the plain text of the code to see whether you have jurisdiction. That's a fairly straightforward 423021. You ask, is the permit properly issued? 423, or excuse me, that's 42302.1, and 42301 says you comply with applicable rules, regulations, and orders, and that's how you know if it's properly issued. CEQA is not one of those rules, regulations, or orders. SRHB is not one of those rules, regulations, or orders, and so there is no jurisdiction. There's a lot of discussion about current energy generally. We obviously disagree with many of those characterizations, but again, I'll just emphasize that the only thing we're here to discuss, not even at this stage, but even at a later stage, the only thing we're here to discuss is a project to purify existing hydrogen. More productive for the company to use. So with that, I'm happy to yield any time.
Thank you. Thank you. Let's see if there are any questions. The board has any questions for any of the council up here. Not seeing any questions there. So let's turn them to see if there are any public comments. And just a reminder that this is, what we're hearing here is the motion to strike the SRHB claim and the CEQA claim. It's not the overall merits of the petition, but to strike those particular causes of action, if you will. So try to limit, I think, yourself to that if you would, but let's see, are there any public comments regarding the motion to strike?
I have the speaker card, so I'll call on names. First, Hector Lopez, please approach the podium.
Okay, Hector. Yeah, just remember as far as microphones go, up at the podium is the best place for it.
All right. Good morning, board members. My name is Hector Lopez, and I'm the director for Health and Safety and Environmental here at Kern. I have 22 years in this industry, and in my role, I have the opportunity to show firsthand how refinery operations and stewardship of people and planet can go hand in hand. The engineering evaluation provides comprehensive descriptions of the hydrogen purification, hydrogenation, and dehydrogenation systems in fuel cells, including capacities and locations where pertinent to air quality impacts. Our technical team is here available to answer any questions that you may have today. Safety is that value that shapes everything that we do, and so we do intentionally design and operate within that core while operating under one of the strictest regulatory environments. Our team selected technology that resembles our current operations and does not rely on combustion, significant heat or pressure, which is a safety-forward approach. The technology at the heart of this project is called liquid organic hydrogen carrier. It's a proven storage method that combines hydrogen with toluene into a stable liquid called methylcyclohexane, or MCH, which is stored and transported at ambient temperature and atmospheric pressure, just like the gasoline components we handle within the refinery today. There's no extreme pressures or temperatures when using this liquid carrier. It behaves like the fuels we already work with every day. To characterize it simply, releasing hydrogen from a carrier runs roughly at the pressure of a bicycle tire. Loading the hydrogen back into the carrier runs at less than a typical home pressure washer. While I do understand the concerns for safety, I want to again emphasize the project components operate within established temperature and pressure profiles within the existing refinery equipment and have been designed by specialized engineers according to rigorous codes and specifications, including monitoring control systems. Kern operates under strict federal, state, and local regulatory environment. We have and will continue to collaborate with these partners agencies. We do recognize producing transportation fuels here in the San Joaquin Valley is a privilege and have integrated a sharp focus on protecting the well-being of our workforce, their families, and our community. Thank you for your time and consideration. Thank you.
Thank you. Next, I'll call up.
Just a reminder too, we do have interpreters here available. If you have a little difficulty with English, they'll be glad to translate your comments into English for you. So I appreciate them being here.
Next, we have Don Van Sickle.
Thank you, Mr. Chairman and board. Allow me to share. My name's Don Van Sickle, and I'm a maintenance supervisor at Kern Energy. And I plan and oversee turnarounds and maintenance projects, tank repairs, and construction. And I've been at Kern for 23 years, but along with that, I've lived in the area for 36 years, over 36 years. And my, this community is my home, and this is where we raised our family. So my wife and I moved out there January 1st of 1990 onto Mountain View Road. So if you're looking at that map up there where that red outline for the project is, it's directly south of that, less than a mile to Mountain View, and then another mile to Lamont. So we've been in the area, and the goal there was to buy multiple acreage to build an equestrian facility. My wife and I have done that with the barns and the arenas and everything. And as I was leaving today, my wife and daughter are out there getting on their horses, you know, that's what they do. We've been there. And another note, we've got an ag well on the property, and we regularly check the water on that. We use it. My neighbor to the north waters his grapes with that, but that's it. We've never had an environmental issue with the refinery there. But, so that's how we landed out there. And my association with Kern started 23 years ago. I was a welder that was working for a contractor that did work at Frito-Lay. I was traveling all over the United States, and I had a young family. I was kind of tired of that, but that same company did work at Kern for turnarounds and maintenance projects. So I was assigned there as a welder, and it turned into kind of a long-term deal. And then the welding supervisor retired, and they offered me the job. And I liked the people that were there. I liked what we were doing, and it was close to home. I could walk to work. Often I will walk to work just to remind myself how blessed I am to be that close to where I work and to work for a good company. And so that's where we ended up. And And what I've seen in the last 23 years at Kern is the changes. Because when I hired, God bless him, but there was one guy, he was the human resources manager and / safety director for the entire refinery. One guy, and since in the last 23 years, what I've seen is, a couple dozen people in our environmental health and safety. And I realize that safety is not just something that we have a poster hanging on a wall. It's what we do every day. Every time we have a meeting, an ops meeting, a turnaround meeting, we have a safety topic. And it's a common thread of situational awareness. What's the worst thing that could happen with the goal of being efficient. And we always have time to do it safely. We always have time to do it right. That's the takeaway from that. We're looking out for each other so we can go home to our families. And it's just the change has been amazing in 23 years. The shift in culture, a concern for the people that work there, investing in the people there, and a concern for the community and the people that live locally. I was just thinking about during COVID, the Christmas parade in Lamont is a huge thing, and during COVID, we okay, I will. Okay, yeah. So, but my concern is I just want everybody to know that it's a great place to work. We've never had any issues where we're at, and this CLEAR project makes a lot of sense. A lot of thought's gone into it. I have a lot of confidence in the people that design it, that are going to build it and maintain it. And then I'm just proud to work for a company that's going to take responsibility for what we're doing. Thank you. Sorry for running late.
Thank you. Next up, we have Melinda Palmer.
Three-minute limit, so kind of keep your eye on the time up there. We'll all be able to go to lunch a little bit quicker, so.
Good morning, Chair, members of the hearing board. My name is Melinda Palmer. I'm the Vice President for Regulatory and Public Affairs at Kern Energy. I've had the privilege of working there for 15 years and had a seat at the table in shaping the evolution of our business. Kern's a small independent refinery, actually the last small refinery remaining in California. As I think you heard earlier, we've been in the community for over 90 years. It's with strength in my voice that I can tell you that we designed this project in direct alignment with our company vision of leading California's clean transportation fuel evolution while being stewards of people and planet. We're a critical fuel supplier in the Central Valley, the state's breadbasket and major transportation corridors, providing fuels that keep our economy moving and our community moving. We're the only refiner between the major complexes in Los Angeles and the Bay. This refinery efficiency project is the next step in improving our operation, consistent with a long history of embracing change and supporting state goals. One of the key processes is naphtha reforming, which in addition to making gasoline components, also releases hydrogen as part of the chemistry. With this project, we couple existing infrastructure of the refinery with new technology to use that excess hydrogen in order to support our facility operations and make clean electricity. In doing that, not only do we reduce our own reliance on the grid, it also improves that grid stability for the community. By recovering and reusing the hydrogen, we improve the efficiency of the refinery of our existing equipment, reducing greenhouse gas emissions by about 15%, and also lowering NOx, SOx, CO, and particulate matter. All of these significant achievements for our local air quality. You heard from Hector already, but I will echo that safety is a core value embedded at our company. We appreciate that it's top of mind for our community. It is for us too. We provide more than 200 high quality jobs, opportunities for team members of all kinds of backgrounds. The project itself will add 9 new permanent jobs and union construction jobs during the build phase. At Kern, we invest in the future. We embrace the spirit and the challenge of solving hard problems. The merits of this one are far-reaching, and we respectfully ask the board to consider the full record before you make a decision today. We're glad to answer any questions you might have.
Okay, thank you. Next, we have Lisa Keel.
Lisa.
Good morning, board members. My name is Lisa Keel. I'm here on behalf of Ashworth Leininger Group, who was contracted by Kern Energy to provide an independent technical analysis on air quality compliance for this project. I've worked for ALG for 20 years. I hold a master's degree in mechanical and environmental engineering and a bachelor's in environmental science and toxicology. Prior to working with ALG, I was a permit engineer in the Major Source Division at Santa Barbara County APCD. ALG provides independent technical analysis on air quality compliance for energy projects across the state. I've reviewed the materials presented to the district for this project and would like to offer a few key points as it relates to the air quality merits of this project that it will bring to the San Joaquin Valley. Kern Energy's project plays an important role in industrial decarbonization in San Joaquin Valley and the state of California. There is an anticipated reduction of approximately 30,000 metric tons of greenhouse gas emissions per year, both due to reductions that will occur on site from reduced combustion activities, as well as reductions in the delivery of off-site resources. In addition, Kern estimates approximately 2 tons per year of NOx emission reductions associated with operational efficiencies that will be gained due to reductions in combustion equipment that will result from Kern's project, such as reductions in heater use, the cogen, as well as flaring. The operation of the existing cogeneration unit results in emissions from the combustion of fuel gas, and that's used to create the electricity. In contrast, the fuel cells, a part of this project, they operate by way of an electrochemical reaction of hydrogen. There is no combustion that occurs, and thereby no resulting combustion emissions from the electricity to be generated by the fuel cells. Kern has conservatively assumed a small increase in VOC emissions from piping connections that will deliver the hydrogen produced within the refinery through the purification system and onto the fuel cells. These connections will be installed using best available control technology to minimize any fugitive emissions from those piping connections. And additionally, those potential VOC emissions will be offset with emission reduction credits according to district rules. This project has been carefully reviewed for consistency with air quality regulations as documented by the district in their engineering evaluation and authority to construct issued by Kern. And in conclusion, Kern's project brings real emission reductions to the community, as I've mentioned, regarding greenhouse gas emissions and criteria pollutant emissions to the community. And this is something that we want to encourage operators to do, to invest in, and to be a part of, so that collectively we can continue to improve the air quality in San Joaquin Valley. Thank you.
Thank you. Next is Diana Morales, and she has indicated she would like interpretation.
Up. I don't know if we do have anybody on Zoom.
We have a couple.
Okay. Just for the benefit of the Zoom members, when we get to you, we do have the interpreters available here, and they can translate your comments into English when we get to you.
Miembros del board. Mi nombre es Diana Mireles, soy presidenta del Comité Progreso de Lamón y también soy miembro del comité directivo de la AB 617 de Alvin y Lamón. Estoy aquí porque sé lo importante que es para la comunidad, sobre todo SICUA. Nosotros hemos estado involucrados por años abogando porque todas las regulaciones sobre SICUA se hagan eficientes. Es importante esta vez que tomen en cuenta lo de SICUA, por la razón de que sí, ya tienen un permiso, pero cada proyecto nuevo tiene que ir por ese proceso. ¿Por qué? Los bomberos, los paramédicos están completamente adecuados para una tragedia. No estoy diciendo que va a pasar ahorita, que va a pasar mañana. A lo mejor cuando yo no esté aquí puede pasar una tragedia. ¿Están preparados? Eso es por eso que estamos nosotros abogando para que se hagan esos estudios de SICUA y también qué tanto nos va a contaminar. En julio de del 2013, perdón, exactamente me recuerdo porque yo iba al hospital, una nube desde la refinería a los tanques que están en el otro lado, una nube. No era diciembre, no era enero para que dijeran había neblina. ¿De dónde venía esa nube? Explíquenme esa nube. Está contaminando. Hablando del SRHB, me siento desilusionada. No quiero que se ofenda a nadie del Distrito del Aire, porque nos tomaron en cuenta a Arvin y Lamont para hacer estas reducciones de contaminación. La refinería está dentro de los límites del mapa que la comunidad escogimos. No nada más es poner las banquetas, no nada más es poner las barreras vegetativas, lo que se mencionó, no nada más es los programas que tenemos, es reducir la contaminación que nos está afectando a la comunidad. Y la refinería es una de ellas. Por eso pedimos, no exijo, pido, con respeto, que por favor tomen en cuenta todos esos estudios de SICUA, porque está en juego mi familia, mi comunidad. Tenemos una comunidad cerca, tenemos una escuela cerca de la refinería. ¿Qué va a pasar? ¿Cómo nos van a responder el día que haga un desastre? Como mencioné, a lo mejor ya no estoy aquí, pero ¿cómo le van a responder a mis nietos, a mis bisnietos? Gracias.
Hello, my name is Diana, and I'm here today to talk about the importance of CEQA for the community. I am the president of the Progressive Committee and also a member of the AB 617 committee. The CEQA is very important for our community, and I have been advocating for the CEQA so that the air quality is regulated. Paramedics and the medics are the doctors. Are they prepared for a catastrophe? That is the question that I have for our community. Another thing that I experienced is that in July of 2013, I saw a cloud from the refinery too. It was not December, it was not January for it to have such a cloud. It was contamination. I also want to express that I feel disappointed, and I don't want the district to think that I'm not appreciating their efforts, but I do feel disappointed because the refinery is inside of the AB 617 limit. It's not about creating these projects about the sidewalks or the bike lanes. It's about reducing contamination in the community. That is why I ask respectfully to take into consideration all the CEQA studies so that our community has better air quality.
Okay, next we have Maria Martinez.
I appreciate that you both are here, but that wasn't a full reflection in Spanish. So I don't know if there's a way to translate maybe more precisely moving forward, but also have a more precise translation of the comments in Spanish.
I agree with that.
Hola a
Speaking of
todos.
Spanish, you know, that this is a summary. I've seen other situations where we do this, you say a couple sentences and then we just translate as we go along versus trying to write it all down. Maybe you could do it that way, better say something and you translate. Then we get it on the record, much better. We get it verbatim, so to speak.
Through the chair, also, it is recorded on Zoom and it will be on our Zoom recording on the district website after the meeting.
I think this approach makes sense because I think it'll make it easier because they are agreement.
And I think they'll probably be a little easier on it.
Ok, hola a todos los que están sentados hoy esta mañana aquí en estas sillas. Mi nombre es María Martínez. Soy de la comunidad del Fuller Acres. He vivido ahí por más de 35 años y he escuchado a los que trabajan para esta refinería maquillar muy bonito todo este proyecto del hidrógeno. Están diciendo que es algo que nos va a beneficiar a nosotros como comunidad, que va a proveer más trabajos, pero lo que yo me pregunto, ¿a mí en qué me va a beneficiar? Mi casa va a seguir siendo igual.
A few sentences at a time.
Para comentar todos aquellos que piden interpretación, por favor, lo vamos a pedir que tomen una pausa mientras
Ujú.
están expresando sus
Ok.
comentarios para
Ujú.
poder traducir adecuadamente lo que están expresando.
Ok. Hola a todos los que están esta mañana aquí en la silla sentados. Mi nombre es María Martínez.
Good morning, everybody. My name is Maria Martinez.
Soy de la comunidad del Fuller Acres.
I'm from the community of Fuller Acres.
He vivido ahí por más de 35 años.
I have lived there more than 35 years.
He escuchado esta mañana a todas las personas que trabajan para esta refinería
I've heard from everyone that has worked at this refinery.
decir las cosas más bonitas de este proyecto del hidrógeno,
I've heard the nicest things said of this hydrogen project,
como que va a beneficiar a la comunidad,
as if it would benefit the community,
que va a haber trabajos,
that there will be jobs.
pero yo me pregunto,
But I ask myself,
¿a mí en qué me va a beneficiar?
how will I benefit from this?
Ustedes trabajan para la refinería, pero igual se van a sus casas.
You work for the refineries, but you go back to your homes.
Y nosotros vivimos ahí las 24 horas y todos los 365 días del año.
But we live there 24 hours a day, 365 days a year.
Hemos sentido el impacto de la refinería
We have
porque
felt the
ha,
impacts of the refinery,
porque ha habido violaciones constantemente
because there have been constant violations
en liberar los aires tóxicos y se puede oler alrededor de la comunidad.
you need to release some of those toxic contaminants, but you can yet smell it in the air.
Ellos dicen que trabajan para la comunidad y que son nuestros amigos,
They say that they work for the community and they are our friends,
pero yo les pregunto,
but I ask,
¿han ido a nuestras casas a preguntarnos qué clase de enfriamiento tenemos en nuestra casa?
what kind of air conditioning do we have in our homes?
Muchos tenemos un cooler de ventana
Many would have air conditioning from windows
que jala lo de afuera para adentro.
that pulls air from the outside to the in.
La mayoría de personas que vivimos en esta comunidad
The majority of residents that live in this community
somos campesinos,
are field workers,
personas mayores de edad,
elderly,
niños.
kids.
¿Cómo nos va a impactar este proyecto?
How will this impact us?
No lo sabemos.
We do not know.
Nadie vino a nuestra comunidad, a nuestra puerta, a preguntarnos si queríamos este proyecto en nuestra comunidad o no.
Nobody came to our doors to ask us to a community if we wanted this project or not.
¿Por qué?
Why?
Porque somos una comunidad pobre y tenemos que aceptar todo lo que los que están arriba quieran poner en nuestra comunidad.
Because we are an impoverished community and because those we must accept that those that are on top must accept this?
No, porque nosotros también somos seres humanos,
No, because we are also human.
no somos animales.
We are not animals.
Pagamos nuestros taxis
We pay our taxes.
y los que podemos votar
And those that can vote,
nos invaden el buzón cada año para decirnos vota por esta persona,
they constantly mail our mailboxes
vota por este
to
proyecto.
vote for this person or vote for this project.
Y ahorita que nosotros los necesitamos a ustedes, ¿están ustedes para nosotros?
And now that we need you, are you guys there for us?
No,
No.
no. Porque, ¿qué va a pasar el día que este hidrógeno contenido debajo de la tierra explote?
What would happen when this contained hydrogen explode?
¿Están preparados para una emergencia así?
Are you prepared for an emergency such as?
Nadie nos ha dicho qué hacer,
No one has told us what to do,
a dónde ir,
where to go,
cómo lo van a resolver.
or how will it be resolved.
Refinería va a embolsar dinero.
The refinery will pocket money.
¿Y nosotros qué?
And where will we stand?
¿Nos van a recompensar de alguna manera?
Will
lo
we
que
be-
ustedes quieren hacer.
Will we be compensated in some manner for what you want to achieve?
No, yo los invito a ustedes,
I invite you all,
a CICUA,
a CEQA,
a AB 617
to ABC
y a
7,
ustedes sentados en esa silla,
and those
que
seated
piensen un poquito.
to think a little.
¿Qué harían ustedes?
What would you do?
Si alguien pone algo dentro de su yarda o de su casa nada más porque yo tengo dinero o soy más alto que tú, ok, yo ahí te lo voy a poner porque yo quiero hacerlo.
If something will be placed in your community, in your yard, because I have more money or I have higher authority.
Así no trabaja.
That's not how it works.
Cuando tú le haces la plegaria a la bandera, dice que hay justicia para todos.
When you make pledge to the allegiance to the flag, you say that there's justice for all.
Entonces, háganle justicia a las comunidades pobres también.
Then do justice for those impoverished communities as well.
Es todo. Muchas gracias.
That's everything. Thank you.
Just for the record, want to just reflect and maybe Sabrina can tell us, we've added a little bit of extra time for the translation.
Yes, for anybody needing translation on their comments, we're doubling the time.
So I guess next.
Alicia Hernandez.
Hola, mi nombre es Alicia Hernández.
Hello, my name is Alice Hernández.
Yo tengo más de 20 años viviendo menos de una milla de la refinería.
I have more than 20 years living less than 1 mile away from the refinery.
Ahora sí que la refinería está en el jardín de mi casa.
So the refinery is in the backyard of my house.
El área donde yo vivo es una área pobre.
The area where I live is poor.
Nadie nos toma en cuenta.
No one thinks about us.
Tenemos problemas también con el agua contaminada por culpa de la refinería.
We also have issues with contaminated water because of the refinery.
Yo siempre me he sentido frustrada porque hemos ido a varios lugares a hablar y nadie nos escucha.
I've always felt frustrated because we've gone to many places to talk, to speak up, and they don't hear us.
Unos meses atrás hubo un escape de unos contaminantes de la refinería
A couple months ago, there was a contamination leak from the refinery.
y de los trabajadores cayeron varias personas al hospital.
And from the workers, many people went to the hospital.
Y yo como que vivo ahí, nadie fue a tocarme la puerta de mi casa a decirme que había pasado algo y que estaba en peligro o que todo iba a estar bien.
And me, that I was living so close by, no one came to tell me that I was in danger.
Es frustrante porque nosotros ya hemos ido a varios lugares y vamos a hablar y nadie nos toma en cuenta.
It's frustrating because we have already spoken up to other places and they don't take us into account.
La área de Lamont y de Arvin somos muchas personas, no nomás no somos una comunidad tan pequeña, somos una comunidad grande.
In Urban Lemon, we're not a small community, we're a big community.
Y yo creo que no están preparados para una emergencia porque yo todas las noches me duermo pensando que si se escapa un aire, aceites o líquidos que nos afecten a nosotros en la noche, ya no vamos a despertar.
And I don't think they're prepared for such an emergency if there is a leak from oil, gases, or dangerous liquids. And I think about me sleeping and thinking I might not wake up.
Y ahora con este nuevo proyecto que tienen, una explosión sería muy fatal para toda la comunidad.
And now with this project that they have, an explosion would be a fatality for the community.
Y hablan de que es algo beneficioso para la comunidad, pero le beneficia a ellos, no a nosotros. A mí no me beneficia en nada eso.
And they talk about it being a benefit for the community, but that does not benefit us. It only benefits them.
Esta área es muy bonita y yo vivo muy a gusto ahí y yo quiero que mis hijos y mis nietos tengan un lugar seguro donde vivir.
This is a beautiful area, and I love living here, and I want a better future for my kids and my grandkids.
Gracias, es todo.
Thank you. That's it.
Expanded the time with the interpretation portion. We want to give everybody a chance to talk and including the interpretation, but we've been a little loose on focusing really on what we're focused on here, which is the CEQA and the SRHB motion to strike. So we could kind of try to focus your comments on that. I think it'll be helpful. Okay. So
Next up, we have Tim Prado.
Good morning, members of the hearing board. My name is Tim Prado. I'm a member of Lamont, and I'm also the vice president of Comité Progreso of Lamont, and also a member of AB 617's steering committee. The district, I am here to oppose the district's motion to strike down. The district claims that the hearing board cannot consider CEQA or SRHBs. I totally agree incorrectly. CEQA is required by the district rules. If the district fails to enact as the leading agency and fails to analyze the cumulative impacts, the board must hear this argument. The SRHB was adopted by the district to protect communities like mine, ignoring and finding permits. Ignoring the findings, it is a permanent evaluation rendering the SRHBs completely meaningless. I am directly impacted by the current energy refinery. The facility already impacts my health, quality of life. Allowing the hydrogen project to move forward without considering these laws is unjust. It is only adding to emissions that we already suffer from. You have the power to ensure the project is fully scrutinized. Do not allow the district to get away with technicality. Sorry. Please reject the motion. Please reject the motion and let the procedure proceed. Thank you.
Next up, we have Bianca Santoyo. No.
Good afternoon, board. Thank you for giving us a space to give our public comments. My name is Bianca Santoyo. I'm a community organizer for Center Race Poverty and the Environment, but also I am also a resident from the community of Arvin. I participate in the AB 617 not only as a CSC, but also as a co-lead. And I've seen the frustrations from my community because I consider myself part of the community in the ways that the current energy has done in the past and all the permits that they have gone through the air district without acknowledging the residents' input. This is really important as CEQA has been challenged in this case, and the way that environmental impact have been sourceful in this area, especially because part of it is being in the AB 617. In this, I did wanted to add that through the blueprint, CARB did give the jurisdiction to the air district to enforce any type of emissions inventory as a statute to enforce it and make sure that it complies as an emission reduction through the AB 617. And it hasn't been done. This is a big impact for the community, for the residents, for the not only from the Fuller Acres, for the Lamont area, but for the Arvin area too. Because as many of these comments have said, they don't have the adequate response, rapid response, not even through the county, not even through the air district. And giving this permit is an assurance that people could pass boundaries because of your power. And this is not about a power. This is about the safety of residents. This is the safety of our health, the air quality. We were selected as an AB 617 community because we are already at Burton through the whole air quality that has not been attained. We've seen it in multiple occasions where the air district has not been attaining their ozone or their PM 2.5, and adding the hydrogen is adding another ticking time bomb. Through the CEQA analysis, it's an environmental impact, and it should be added through that report and included in this permit. Because if not, we're just waiting for residents to die. We've seen residents coming out. This is not something that you guys have seen just for a couple minutes. This is a long background for them to understand and to learn about it, to educate themselves. So these are hours and countless hours of them coming to you, making sure that these comments are reinforceable of the work that they are doing at the moment and what their living experience is at. I also wanted to give an extra comment because my colleague also sent me a message. Yes, this is my last comment. At the moment, there's a spike of H2S. And if you see it through the Air District website, that's alarming. That's another way that you could tell that that Kern Energy has not been a very helpful emissions inventory in there, because they're also monitoring and they're not fulfilling their duty.
Okay, next we have Cesar Aguirre.
My name is Cesar Aguirre. I work with the Central California Environmental Justice Network, and want to raise alongside the spike that happened today at the Kern Energy Fence Line Monitor, the history of where those emissions come from and where they go based on the windrow data. And that is that more than 75% of the time, close to 80% of the time, from when I signed up to this notification in the middle of 2024, the emissions start in the refinery and move towards communities in the area. And noting that the California EPA also made a activity log, 2 separate activity logs that show a compliance history of repeated offenses, not correction of actions, not doing better after getting a notice of violations. They are taking the violations as a cost of business and continuing to break the rules over and over again due to a lack of proper oversight, compliance, or any other statutory enforcement that would prevent these things from reoccurring. This activity log demonstrates that they do not have intentions or efforts to correct these issues, as they are reoccurring for years and years and years. And thus want to point that is an issue with the fact that the California Environmental Quality Act is something that should provide protections for communities, and these repeated offenses and the fact that they have basically made NOVs a cost of doing business is something that should be addressed properly, seeing as the SRHB is a community emission reduction plan where there was action in this CSC that has not been done anywhere else in California, where CalGEM has been invited to do inspections, where we have an oil and gas subcommittee. There's no oil and gas subcommittee in any other CSC in California for AB 617. And so the reason is because we are affected quite heavily from this site due to repeated spikes that happened in April. There was an unknown blockage that was there for an unknown time that was causing an increase in the tanks at Kern Energy on the east side of the 184. How long was that blockage there? Why was it there for so long? One of the only reasons that action was taken was because we have an infrared camera. We do inspections, and we did follow-up inspections post the reporting inspectors that came in from the district. This is a continued issue. They need better review, and giving them a permit to one of the smallest molecules in the universe that is difficult to hold in just shows that if they can't hold H2S, as they demonstrated this morning, and control that substance, I really doubt that they would be able to do things properly in an environmental protection way. Thank you.
We're not really concerned here with the larger aspects of the petition. We're really only thinking about whether or not it's appropriate to have a CEQA and SRHB causes of action, if you will, in the mix. So just bear that in mind in your comments, but next.
I don't have any others. Oh, there's one coming. Okay. Next up, we have Emmy De La Rosa.
Good morning, board. My name is Emma De La Rosa. I'm a Land Use and Transportation Policy Manager with Leadership Council for Justice and Accountability. I've had the privilege of working alongside residents of Lamont and residents of Fuller Acres for about 6 years already. And it's been a great privilege because they have taught me so much. But especially what they have taught me is the impacts associated with the refinery. The reason why residents continue to bring the issues related to their health is because when you are when you're proposing a project or you're considering the impacts of these projects, you have to take a look at the impacts that residents are currently facing, the environmental setting. That you have to consider the current condition, right, of the community and of the project location. And in doing that, you also have to consider the health-related impacts, the population impacts, the social impacts associated with projects. And so with residents bringing up concerns about their health and their quality of life, it's because CEQA would help address some of those issues. So I did feel inclined to provide that comment because we want to ensure that the comments that residents are providing are validated under the CEQA, understanding. And I think when it comes to the air quality issues, the violations issues, again, we have to take a look at the manner that the refinery is currently not violating or violating, and taking a look as to why some of those violations are taking place, and assessing how CEQA, again, and looking at CEQA and how it could help reduce the risk of violations, the risk that there will be continued emissions, contaminating in the area. The refinery mentioned that they conservatively identified a small VOC release, but that conservatively doesn't give us any actual indication of how that emissions, of how those VOC emissions will actually impact the health of the community without an environmental assessment. So again, that's the reason why residents are bringing up health impacts. We really hope that you will take these comments into great consideration and make the connection between health impacts and the environmental impact report that should be required for this project. Thank you.
Seeing none other in person, I'll go to Zoom. The first on Zoom is Renee.
Hello. Can you hear me?
Go ahead.
Thank you. My name is
Yes,
Renee.
yes.
Renee Donato Nelson. I'm with Clean Water and Air Matter. I've been a CEQA consultant and worked in that field for over 35 years. I am very aware of the air quality issues in this community, but I'm only going to address the CEQA issues. First of all, you have to ask yourself, is this permit a project? From what I've heard from the engineers and from staff, yes, this is a project. That's the first criteria for CEQA evaluation. So you do need to do some type of CEQA evaluation. It isn't up to you to say yes or no. That's up to the law, and statutorily, a project needs consideration. If you don't feel that you have the authority to vote on that because you're not a elected body, then it needs to go to the Board of Supervisors, who are the lead agency. You would then become the responsible agency, as you do in many other projects themselves. I'm asking that you understand the process, and that's what we're looking at here. I'm not going to go into the SERP, but I am a little concerned that you, as the agency hearing the permit application, are allowing a motion to strike by your staff against these two areas. I don't understand that. I don't understand the authority for you to do that, nor do I think it's appropriate in this fashion. And I hope that you will understand that you
The
do.
conference recording will end in another 10 minutes.
Oh, thank you. I only have 132, but all right. Thank you. I'll stop there and do the right thing.
I'm sorry, that was Zoom activated.
that's
You can
okay.
continue speaking.
Just, you need to, it is a CEQA project under the law. You need to analyze it as such, do an EIR or whatever document you find to be necessary, but it is definitely a project. I'm not saying it's a bad project. I'm not saying it's a good project. I understand the record of violations with this company. I've followed it for years. We can do better. They need to do better. And you need to not interpret everything so closely that it defines it out of the realm of your responsibility. And that's kind of what you're doing. So thank you again for the opportunity to speak. I appreciate it. And I appreciate all the commenters. It's been very enlightening. I'm done. Thank you.
I think we probably have enough, and we just have one more person on Zoom.
There's a couple more comments on Zoom that have popped up. Jennifer Martinez Medina.
Hi, my name is Jennifer Martinez Medina, and I'm here as a community member with strong home ties in Fuller Acres. Just to give you a little context, after 6 months after my birth, we moved to Fuller Acres. So, I've been around, my family has been around for over 37 years. And I've really seen this community grow, and I've also seen the oil company sprawl and deepen its pipes and bring even more semi-truck traffic carrying diesel fuel. And I'll defer to the 184 community representatives to make all the precise cases around legal concerns, and also my neighbors to provide testimony of lived experiences. But members of the board of San Joaquin Valley Air District, I want to focus my comment to simply ask you to enforce the law. CEQA and SRHB should apply. Listen to community members and our concerns regarding this permit, and I want to remind you that our lived experiences and their lived experiences is also a valid form of knowledge. And I'm here virtually because the Valley Air District has ignored the expressed concerns of the community members and also adjacent communities around 184. Currently, there are massive incentives for renewable energy from federal and regional governments. However, Kern Energy is utilizing their hydrogen project to expand extraction of fossil fuels through methods of what I would say public deception. This project will not put us at the cutting edge of renewable clean energy. It really takes us back and keeps us tied to the eventual demise of oil. Just because this is a good project for the refinery, it doesn't necessarily mean that it's good for the community. And I think community members have made that case already. They've also talked about the long list and routine violations of the refinery. People have alluded to not too long ago how many employees were taken to the hospital after being exposed to toxic substances like hydrochloric acid. This morning, there was another hydrogen sulfide leak, according to air monitoring systems. And every time there is a violation, our communities are not notified. None of us are offered medical attention. Very few media outlets cover these type of violations. And this is an example of how this refinery consistently poses as a bad actor in our community. And the Kern Energy is a well-oiled company, right? They really protect their image. And so I'm really asking you as legal bodies to not look the other way. Please take the opportunity, take the responsibility to act on these community concerns. Our neighbors are forced to take on these externalities. And we all deserve the right to live with dignity. Our elders, our young ones, our parents, we all deserve to live here. This is our community as well. We're not leaving, and we need to find a way to protect our ability to thrive here. Thank you so much for your time.
Let me just ask the clerk, do we need to somehow reboot the Zoom so we have more time?
Through our IT, I think they've added 2 hours to the meeting just to be safe. We have a cushion here. So as long as the meeting remains active, it will continue.
Okay. So we'll go to our next Zoom comment.
Okay, the next one is Christian. Go ahead, Christian.
Hi, good morning, or good afternoon. My name is Christian Bisher. I live in Fresno, and I work for the Central California Environmental Justice Network. I was an air permit engineer at the San Joaquin Valley for 4 years, from 2020 to 2024. I completed permits similar to the one in question today. When I or any engineer works on a permit, a different section work on the CEQA portion of that project. The district has 4 CEQA policies and over 100 internal documents called FYIs since I left, they may have been renamed to SOPs, that direct district staff actions on many specific CEQA aspects. At the end of every single application review for a district permit, there is a CEQA section. This CEQA review within the permitting process impacted permitting many times while I was at the district. I myself had a permit for a concrete production facility that wanted to expand. When district staff determined themselves that the lead agency did not complete CEQA properly, my work stopped. Permit department management would not allow me to complete and issue the permit that I was working on until they were satisfied CEQA was completed properly. I ended up leaving the district before this work was even completed, so the permit still remained unfinished when I left. And there were numerous other examples of my coworkers experiencing the same thing. So the point I would like the board to understand from this is that the district air permitting occurs with CEQA. When the district is a responsible agency, meaning the county or a city is the lead agency and primarily responsible, district staff still review CEQA to ensure it was done properly. And if it wasn't, district air permitting work stops until it's corrected. So to clarify, the actual CEQA determination may be done with a different agency, but the district does not blindly accept whatever decision is given to them. They review it when they're working on the permit. And if they determine it is incorrect, air permitting work stops until it's corrected. And if it's not corrected, the permit is not issued. So challenging a permit's issuance with respect to how the district staff address CEQA, that is part of the air permitting process at the air district. And so this issue should be heard at the hearing board. Lastly, I would like to just add, you're hearing from other people. If you still have questions about CEQA and the air permitting process, in that building, there are air permit engineers and air quality specialists that do that work. I would ask you to have staff bring them in and you can ask them directly and you could hear from them exactly how CEQA is used in their work. Thank you.
Okay, next we have Elizabeth.
Can you hear me?
Go ahead.
Yes.
Okay, sorry about that.
Yes.
All right, good
Yes, we
afternoon.
can.
Great. Good afternoon. My name is Liz, and I'm here on behalf of Building Healthy Communities Kern. In my role, helping others navigate local resources, whether it's food assistance or hearing personal stories, I work directly with families across the Kern region, including Lamont and Fuller Acres. And I'm here today in support of Leadership Council. A lot of the families we work with are dealing with basic environmental issues like struggling to access clean water or dealing with pollution right next to their homes. When new projects are proposed, there is a real concern about safety risk or increased heavy-duty traffic being added to the neighborhoods that are already impacted. Well, we're just asking for transparency. It's important that CEQA and AB 617 are allowed to be considered during this process. A full environmental analysis should be done so that residents can actually know what impacts might be coming. And that's all I really wanted to say today. So thank you so much for your time.
Thank you. Next we have Clean Water Action is the name on the account. Go ahead.
Clean Water Action.
Hi, yes, can you hear me?
Yes.
Wonderful. Good afternoon. My name is Jesus Alonso. I'm the community organizer for Clean Water Action. I'm also a Lamont resident for 35 plus years. And so I can tell you firsthand my experience with Kern Energy and the refinery. It's definitely one of weariness, which is why we're supporting to follow through with CEQA, with the CEQA evaluation and abide by the SRHB, as both the Air District and Kern Energy made a commitment to our communities in participating in the SRHB. And now it sounds like
the conference recording.
Now it sounds like there's some sort of backtracking from both parties. Kern Energy has a history of violations, which I have seen firsthand living here in the community. Just about every other year,
We see large plumes of smoke or firefighters constantly going to the refinery. And it is concerning. And so now with them getting a hydrogen project, it only it only multiplies that concern. Because my son soon is going to be going to that middle school less than a mile downwind from the refinery, and I don't want him nowhere near a location that has a long history of violation. And that's everything I wanted to share. Thank you.
There's no other online comments, and just so you know, the conference is still being recorded. I think that was an auto-generated
Okay.
announcement.
So did we have anybody in Fresno? I don't see any.
Fresno, do we have any members of the public that would like to comment there?
No members in Fresno.
Thank you.
Okay. Well, with that, then we'll close the public comment portion of the hearing, and I'll and we've heard all the arguments, so let's go to the board and see if there is discussion. Any discussion, board members? Okay. I would just add that remember on the question on CEQA before us is whether this board has the jurisdiction to make that determination. So some other body may have that power, but the question is, do we have that power? Okay, with that, then.
My 2 cents at all.
Yeah, obvious. It's more than 2 cents. It's probably $50, maybe 25.
I just wanted to say, I've represented air pollution districts, this one in the past and others for over 40 years. And back in the 1980s, I can remember this topic starting to be discussed. In the old days, air pollution control districts were a little bit slow to comply with CEQA, and over the years, they realized they have to do it. But the question here is not whether CEQA needs to be done. It's a question of whether you have jurisdiction to hear an appeal of a CEQA determination. And I will say the consensus of air pollution districts and air pollution district councils statewide is that the hearing board does not have jurisdiction in situations like this. And your jurisdiction's limited. This thing's gotten thicker over the years. It used to be a really thin book. This is all the rules and the statutes that apply to districts. And in the permitting, especially the section on whether the permit's properly issued.
Conference recording has started.
This is all in Chapter 4 of the Health and Safety Code. And it speaks in terms of the APCO, the district, processes permits, and it does not issue a permit. It prohibits them from issuing a permit unless it complies with all applicable orders, rules, and regulations of the district and of the state board, the State Air Resources Board. And then you have to read these sections as a whole with this chapter. And it goes on, talks about, what you do when somebody locates one by a school, et cetera, et cetera. And then there's a whole bunch of things that the APCO can do. They can deny permits. They can issue a permit that was denied. They can overturn a suspension of a permit. But it all speaks in terms of, was it properly denied? Was it properly revoked, et cetera. But the bottom line is they can only revoke a permit if it's a violation of this part or any order, rule, or regulation of the district. That doesn't include CEQA. It's in a totally different wheelhouse. And it doesn't include AB 617, which you've heard is basically a planning document. It's a legal charge to the governing board of the district, not the APCO, to come up with programs and new rules and ways to mitigate air pollution in areas that are adversely affected, environmental justice areas. If there are problems, I've heard a lot of testimony with, oh, geez, the district's not doing this, they're not doing that. In that context, AB 617, that should be addressed to the governing board of the district. They're the appointed board of elected officials who do that. They do planning, they pass rules. The APCO applies the rules. The two cases that I find significant, I'm familiar with these, the Covington case and the CBE case, they basically said CEQA and the hearing board, this hearing board concept, it's irrelevant to CEQA. The CBE case was a situation where the plaintiff was complaining about what I call the arithmetic, which you guys are going to be getting into in October. You know, were the calculations correct? Was this rule applied, that rule applied? And during that course of the case, the district raised the issue that, well, wait a minute, you know, the arithmetic stuff you're supposed to be doing to the hearing board. The CEQA stuff goes on its own track. You present it, you go to court. And the purpose for that is the legislature wanted to ensure that CEQA cases get decided quickly. They didn't want all these intermediary steps in between. The idea is it's important, you get it going quickly. You go right to court. There's no intermediary. But these two cases basically said, yeah, the CEQA and the hearing board, they're not connected. They're irrelevant. You don't have to go to the hearing board to do CEQA. And that's what the CBE attorney said. No, I'm not attacking the arithmetic. I'm attacking CEQA. And the court said, well, the hearing board's got nothing to do with that. So I think, you know, those are kind of the two most important cases. And I think that's about it. But you kind of get a taste, though, where this thing goes. I mean, this properly issued language, it's not a kitchen sink situation where you can, you know, anything you can think up gets put into this construct of is it properly issued? It's got to be properly issued within the confines of the rules, regulations of the district. And you hear some of this, people talking about, you know, water. What about schools? A traffic accident on Highway 99. It's got nothing to do with your wheelhouse. You got to stick to the rules, and it's conservative because the law is you're a body of limited jurisdiction. If you don't specifically have the power, you don't have it. That's way back to common law days. And so those are my observations on what's going on here. So.
Okay. Thank you, Phil. Any questions for Phil from the board? Comments? If not, we basically got three options here: the approval of the motion, denial of the motion, or doing it in part, one for CEQA, one for SRHB. So do we have a motion from the board or any discussion from the board?
Do we have a chance for deliberation?
No, but
Outside
that's
of the
what I
room?
mean.
Or is
Deliberate,
it
yeah.
public deliberation?
Public
Yes.
deliberation.
Public under the Brown Act. You have to.
That's
Okay.
a Brown Act issue. So.
As a member of the hearing board, I'm a volunteer to serve on this board, and I do agree with the limitations of what this hearing board has authority to approve or deny. In my opinion, with the case of the appeal for this permit, we're looking at judging independently, your words, the permit itself and whether it was issued correctly. There's a lot of arguments within this document, and for me, the CEQA and the SRHB are not applicable to our jurisdiction and what I would be comfortable approving or denying. I would want to just hear, the permit appeal itself, which is the calculations, whether the authority to construct should have been granted based on the merit of the project and whether it complies with the requirements of the Air Pollution Control District Board or Control District itself. So for me, I would move that the motion to strike is granted.
Okay, motion by Ms. Penner,
I would second that motion.
second by Mr. Weber. Corey, anything you'd like to? Yeah. I've just agree with what Ms. Penner said, but just remind everyone in the audience that this is not the end of it. That we're taking away two of these issues, CEQA and SRHB, from this hearing board's determination. Those issues don't evaporate. There may be other forums that they're available in. And certainly in October, we will have a full hearing on the, as Phil says, the arithmetic issues of the other issues that arise in the petition. And I think district has agreed that any factual assertions, they can't be applied to CEQA or SRHB, but they can be argued in regard to those arithmetic determinations. So with that, I guess the clerk would take the roll.
Okay, so this is for the motion and second to strike.
Would you prefer to have Corey read that for him?
I can read it. I have it here.
Our petitioner's right to amend the petition. I'm sure we'll more than likely have a conference in the coming weeks to iron out all of the details leading up to the October 14th hearing. And I just wanted to confirm whether we'll be able to have if we'll be granted the right to amend our petition prior to the October 14th hearing, or should we wait until our next conference to talk about that? I'm sure we would like to have some clarity now that we have the hearing board available.
District Council.
The district's position is that there's no need to amend the petition to allege additional facts. The district's position that any facts that are relevant to the other claims outside of CEQA, you're capable of submitting some facts relevant to those claims that you want. I don't think that you're confined by what is alleged right now in the petition, as far as facts and evidence go to support the other claims.
And in what format should we resubmit those facts and claims?
I mean, it's up to the hearing board, I guess, whether they want to allow you to amend. The district's position, I don't think that there's a reason or a need to amend.
Striking the petition, striking sections B and C would mean striking a lot of facts. And so how should we reinsert those facts into the petition if those sections are being stricken?
Well, I'll ask our counsel to correct me if I'm wrong, but remember at this next October will be a hearing, and you'll have the opportunity to present those facts to the board.
So will those facts be presented orally, or will we also be able to submit them in writing prior to the?
I suspect we could do both.
I mean, to the extent that there's facts in the SRHB argument that you feel are relevant, the arithmetic hearing, you could do it verbally when you get there, or some kind of a position paper. I mean, if you're afraid that there's certain allegations that are just gone because of striking certain pages and lines, you should be able, if they're facts, and not arguing whether the board has legal authority to apply this SRHB, but if there's facts you want to present, that's certainly permissible.
Another question, just to clarify, The authority upon which that you're able to provide. I think we're just wanting to clarify.
Well, I guess usually the district council sits with this board and advises them, but since they're prosecuting the case, they wanted independent, separate counsel to advise the board, and that's me.
That was the basis.
Statutory provision.
No, it's not. But it's, you know, if they need counsel, I think maybe I helped a little bit.
Right.
You just try to find somebody who, you know, isn't involved.
I think we have the right to counsel.
Through the chair, yes. It is typically the case that hearing boards throughout the state are represented by counsel in all areas.
And if there's a conflict of interest in that, then we can't really turn to the district council. So we have to have our own counsel.
The district council can't wear two hats. They can't prosecute and sit with the board, so you have to find someone separate.
Okay. Well, with that, go to.
Conference recording has started.
Apologize. Zoom has got a mind of its own right now. Okay, so I'm calling roll for the motion and second to consider the district's motion to strike the CEQA and certain portions of the appeal. So I'll call for roll. Mr. Stovall?
Yes.
Ms. Penner?
Yes.
Mr. Weber?
Yes.
Okay, through the chair, the motion has passed.
One thing I wanted to ask, you all want some kind of a written decision in this? If you do, I would suggest, since the district's the prevailing party, they draft a written decision and confer with council. If they want, you know, more detail than just a minute order or something like that. You want findings of fact, or, you know, I think maybe you two should all talk about that.
If I may, I can prepare a proposed draft order circulated to the parties for their comments, and then provide that draft order and parties' comments to the chair.
Yeah, I mean, the health and safety code does provide some guidance on this. It does say that the issuance must be made, the issuance of the final decision must be made in writing and copies must be distributed within 15 days. And that the written decision must detail the entire reasoning for the decision in writing. So I think that should guide whatever comes next.
Okay, so what we'll do, since the district is the moving party, we'll have them draft the proposed order, circulated among the parties, and then we'll get the order signed within 15 days. Any other comments on this issue? Okay, if not, hearing board member comments in general. Anything? I would just say that just thanks to everyone, I think, by following the rules, and I think this hearing went very smoothly, and appreciate everyone's cooperation in doing that. Is there any new business? No new business. Next scheduled meeting is September 9, 2026. But I hasten to add that the next meeting at which we will consider this, and it will be a hearing, will be on October 14, Wednesday, October 14. And look forward to seeing you back here so that we can go into some of those arithmetic issues and other issues.
Get out your slide rules.
Right. Okay, so with that, adjourn the meeting.